seated. The first matter before the court is Garey versus Stanford Management. This is Oxford 23-366. I see counsel are present, and I assume you are ready to proceed. We are live on the web, both identify by saying your names for the record together the party that you represent.
Berryment representing the Appellant, Delanna Garey.
Thank you.
Good morning, and together with my colleague Emily Waddell, representing the Appellees, Stanford Management LLC, and Eve Dunham.
Thank you. And Mr. Berryman, if you're ready, I'd be happy to hear your arguments.
Thank you. Good morning, Chief Justice, Associate Justices, my colleagues, Attorneys Russell and Waddell. May it please the Court. These days, in the world we live in, it may seem like people should have and walk around with bulletproof skin, that they should live strictly by the motto, sticks and stones may break my bones, et cetera, et cetera. But the drafters of the Constitution of this state 200 years ago believed that somebody's reputation was important, that the right to seek redress for the wrongful injury to somebody's reputation was important enough to include explicitly in the Constitution of this state. Now, of course, the right to seek redress for the injury to one's reputation must be balanced delicately against others' rights to speak the truth or to speak their opinions. We are here to argue, with respect to the court below, that the court below got that balance wrong in dismissing this case on the face of the complaint. The court below, as this court is aware, dismissed this complaint for a variety of reasons. We think that each of them was an error. The court below dismissed the complaint for defamation and false light, invasion of privacy, because it stated that the statements alleged were too vague. We don't think that they were too vague. We think that they certainly is a construction of those statements that is defamatory, and that if there is a construction of the alleged statements that is capable of being defamatory, then that at least survives a motion to dismiss, probably survives a motion for summary judgment, and is ultimately for a fact finder to decide after a trial. The court below dismissed the complaint, stating that, in the court's view, the statements alleged were a matter of opinion. Certainly, this court has said that if a statement, allegedly defamatory statement, is a matter of opinion and clearly a matter of opinion, then that is a defense. However, the court also was clear, and I think the case is probably Karen to cite for this, that if it may be an opinion or may be taken as a statement of fact, that that is enough to survive even summary judgment, let alone a motion to dismiss. And it's up to a fact finder how the statement would be taken. So we think that this case comes down to the procedural window that we're at. And with that, I'll welcome the court's questions.
Counsel, I see that the green light is on. Counts 5 and 6, which are the declaratory judgment and the injunctive relief.
Yes, sir.
Aren't they? I note that the criminal trespass notice is only effective for 1 year. It was issued February 6, 2023, which would mean that it's expired now. Are those counts moot?
Fair question, Your Honor. We say that they are not moot. It appears that Stanford continues to claim the absolute right to exclude my client from the premises. They have not disclaimed that in their brief. And they could, with or without asking for a criminal trespass notice, according to them, exclude her from the premises. So I don't think that that has been mooted at this point.
While we're talking about the notice, I'm looking at it right here. In the 4 corners of that document, what is defamatory?
Your Honor, I think I would concede within the four corners of the document that there's not a defamatory statement contained within the four corners of that document
Okay, so
alone.
where does that leave us on that point?
If that was the only thing that brought us here, we would,
Okay,
yes.
thank you.
What about the email? Same question.
So on the email, Your Honor, I think that that could be seen as defamatory both on its own, but it also dovetails with the other defamatory statements made in the letter that was sent to each and every resident of the multi-unit building and posted in the public-facing hallway elevator of the building. The email states and suggests that it was the Rumford Police Department that essentially decided to serve this criminal trespass notice. And frankly, this is something in my colleague's brief that I'm concerned with. He suggests that the court should take judicial notice, essentially, as I read it, that the police make the decision whether to serve a criminal trespass notice. I'm not here suggesting you should take notice of the contrary, but I certainly think it's a question of fact whether that's the case.
Are you, in the sense that they act on information that's given to them?
Correct. Did the police act on information that was given to them and make their own determination that it was necessary or appropriate to serve a criminal trespass notice banning my client from this building? Or, as we suggest in our complaint, that Stanford and Dunham asked for this notice to be served and the police, just reflexively served it?
I note that below, the Superior Court dismissed count 4, which alleged punitive damages, essentially on the grounds that there's no longer a tort and therefore there's no basis for punitive damages. It didn't seem like you made any argument with regard to count 4. Are you really only appealing counts 1 and 2, 5 and 6?
Well, yes, Your Honor, I suppose that I think it's more of a matter of style whether we call punitive damages a separate claim or damages, an additional theory of damages. So if they want to call it an additional theory of damages and not a separate count, that's fine by us.
So your view is that basically it's going to rise or fall with the tort claim,
Yes,
as
sir.
the court said. So if we disagreed with the court's treatment or dismissal of the tort claim, then we should also put the punitive damage claim back.
Yes, Your Honor. If the court below and my colleagues see it better to treat that as a matter of damages rather than a separate count, that's all the same to us. It was more of a abundance of caution pleading it that way.
But the letter to the residents doesn't invoke any particular action taken by your client, but it does use the word protect. Is that the hinge pin on your argument that this is a defamatory document?
I think I don't know that it's absolutely necessary that that word appear in the document, but I think it's certainly enough to give the statement potentially defamatory, meaning enough to get us past a motion to dismiss.
But that would have to be a false statement regarding your client. Is there anything on the face of the document from which someone looking at it from 30,000 feet out, like on a 12b6 motion, can assume that that is in fact a false statement? There may have been, in fact, a reason to protect the residents.
Certainly, Your Honor, and that's why we're relying on the fact that on 12b6 motion, the court here and the court below assumes that the allegations are true. We have not conducted discovery in this case. There's been no depositions. No supporting affidavits have been filed either way. I'm not conceding this, but we may very well be in a different posture in this case if we were arguing a motion for summary judgment.
Well, your point is that when you say we needed to take this to protect, it's saying that the plaintiff was a danger, and therefore that's defamatory by saying we had to protect you against her when you link it with the criminal trespassing notice, correct?
When you link it with the criminal trespassing notice and the other statement in the letter that it was behavior.
Everybody knows they're talking about her, and now they're saying we had to take this action to protect people, which let's say it implies that there are facts that you're saying aren't true, correct?
That's correct.
So my question is that defamatory per se? Because it's not really attacking her ability to do her job well. So how is it per se?
So, Your Honor, I don't think that that issue, of course, was directly ruled on by the court below, and in any event, interesting issue. This was, of course, in connection with her employment. And I think it would be, easy to say, well, you know, she's not a doctor or a dentist or a lawyer. You know, she was just an employee. And, you know, they're just saying that she did something that was dangerous enough that had to exclude her from her place of employment. But I don't think that the protections of defamation law should be limited to doctors or dentists or lawyers.
I guess what I'm curious about is, I mean, the complaint doesn't make that distinction between whether it's per se or not. It just says she suffered damage. And in addition to impugning the profession, there's, you know, it could be impugning her with criminal conduct or something else. I thought your position was it's really just a question of fact at this point.
That's absolutely true.
While we're talking about the documents, can we go to the letter to the aunt?
The letter to,
The aunt?
yes, Your Honor, the email.
Email, yeah, email letter. And in that, obviously, there is, I think everyone agrees, an incorrect statement. There was no determination made by the Rumford Police Department. We all agree on that? Is there any question about that?
I don't think there's a question about that. I'm not sure if that's unanimous.
Okay, all right. But within the four corners of that document, what is defamatory about that?
In that it suggests that the Rumford Police Department decided that my client's behavior was such that she needed to be excluded from this premises. Now, even if you don't spot me that that is defamatory on its own, I still think that that lends context to the other statements in the letter to the tenants.
But the letter to the tenants talks about there were recent staff changes, and then as a result of the behavior of former employees. Couldn't that suggest that they're talking about her post-termination behavior as opposed to anything that resulted in her job loss?
I think there's certainly, I guess, some ambiguity on that count, Your Honor, yes.
But your point is basically it's bad enough that it at least raises a question to know what it is.
Yes, Your Honor, certainly. And then once again, at this stage of the case on a 12B6, on the face of the complaint, without the defendants having even filed an answer.
Because at this level, we can't know whether or not there was a false statement. We meaning the court.
Yes, Your Honor, certainly if the defendants could produce evidence that it was a truthful statement, they have every right to say it. If they can convince a fact finder that it was in fact a statement of opinion, then they had a right to say it. But we're not there yet.
Thank you, counsel.
Thank you.
Mr. Russell?
May it please the court. Good morning, Your Honors. Again, my name is Jeff Russell, and I represent the appellees, Stanford Management and Eve Dunham. As you know, in this case, we have the opinion of the Superior Court. We certainly feel that's a well-reasoned opinion. It's clear that Justice Archer gave a lot of thought into this case. We believe she came to the correct decision on each issue. And rather than rehash a bunch of arguments, I am more interested in what the court would like to talk about. But before I get there, I do want to raise just a couple of quick points. First, I think this is kind of low-hanging fruit, but you know, what I basically hear the appellant saying in this case in the briefing, perhaps that's changed today a little bit, is with respect to the posting of the trespass notice, that they would like this court to adopt essentially a rule that the posting of a trespass notice or a protective order could somehow constitute defamation. And I think it's easy to see that that would create a problematic precedent going forward that could have some real ripple effects. And secondly, I think the court has honed in on the fact that this case, the letter is really what this case is mostly about. And the Bacall and Haworth cases have loomed large in the briefing. And we believe that the Bacall case actually is sufficient by itself to decide this case. And Your Honors will recall that the Bacall case involved the owner of the Cliff House property, and they told a third party that they weren't allowing a neighboring landowner to come onto the property due to 10 years of, quote, complaints and threats. And in that case, the law court said that to conclude that the word threat means threats of physical violence is basically inappropriately focusing on the most negative possible connotation of that word. And there are, in fact, multiple interpretations of that word, and therefore the word is too vague to create or support an actionable defamation claim. That is clearly the case here as well. And I can't help but point out a bit of irony here that the appellant is really asking the court to conclude that when my client used the word protect in the letter that they sent to residents, that it meant protect against someone that's dangerous and threatening. There's that word again, threatening. And so the appellant essentially wants the law court to construe a statement as meaning something that the law court has already decided is too vague to support a defamation claim as a matter of law. Bacall remains good law. It clearly applies in this case, and we believe it stands for one of really what's several alternative bases for dismissing the defamation claim. And with that, I'll cede the rest of my, open it up to questions.
On the Superior Court below seemed to say, well, there's no facts from which one can infer that it was actually negligent or that there was damage, et cetera. This is a notice pleading state. I mean, these are not things, it's not fraud that has to be pled with particularity. Why isn't it sufficient to simply say, they made statements, the statements are false, I was damaged? And they negligently made statements, the statements are false, I was damaged. I mean, those are the elements.
So there's a moderate amount of discussion, I would say, in the briefs about the concept of notice pleading in this case. And the appellant alleges that the court applied an unfair higher standard here. We're not alleging here that the complaint should be dismissed due to a lack of specificity. That's not something.
Okay, so despite the fact that that was some of the rulings below, that's not what you're hanging your hat on?
We are not hanging our hat on that. There was some discussion on, in the original trial court level motion practice, I think initially our motion to dismiss did remark that the complaint could have some additional specificity, but I think that was honestly cleared up a little bit in the
Good, it made me think that all those complaints I wrote all those years ago that basically said, you're negligent, it's your fault, you know, that's it.
I think, right, I think the appellant is drawing a little bit of a false equivalency between the notice pleading standard on the one hand and the standard for surviving a motion to dismiss.
Okay, so what you really want to focus on is the contents of the statements which are alleged and whether, as a matter of law, those can be considered defamatory.
Absolutely. All the reasons that the lower court found this case to not present an actionable defamation claim, whether it be vagueness due to multiple interpretations, opinion, conditional privilege, fault, defamation per se.
Can I ask you about conditional privilege?
I'm sorry.
Can I ask you about conditional privilege? I mean, that's, as you know, that's an affirmative defense, and usually affirmative defenses are matters that are left to proof. The burden would be upon the defendant to prove them, and in this instance, it would be demonstrating that it's a situation in which an important interest of the recipient will be furthered by frank communication, and that may give rise to a conditional privilege. And then, of course, you know, the other side to that is whether or not the exercise of the privilege was constituted abuse or that malice was shown. And I'm wondering whether at a 12b6 motion, whether conditional privilege is even appropriate for consideration at that point. In other words, you would lose that privilege if, in fact, they proved there was malice. But these are all highly fact-driven issues there. And we've never, I don't think we've ever blessed conditional privilege at a motion to dismiss. Matter of fact, after judgment, we've said that conditional privilege turns on facts. So is this really something that we can hang our hat on and the court below can hang its hat on?
I absolutely think it is, Your Honor. And first of all, with respect to the issue of affirmative defense, since that's where you led off with, I think the issue is a little bit more complicated than that. The black letter elements of a defamation claim contain a requirement that the plaintiff present an unprivileged publication to third parties. There's case law that makes very clear that a prima facie showing of unprivilegedness needs to be part of a showing. Even if the court were to construe this situation as an affirmative defense, we're very comfortable that the burden has been met here.
But you have to show it on the four corners of the complaint. And the complaint here simply says that your client made false defamatory statements and leaves it at that. Do you get a free ticket by saying, well, it's an important communication that the recipient would benefit by frank conversation? Does that get you off the hook?
Absolutely. The nature of the relationship of the parties, the interests at stake in making that frank communication, as supported by case law, as supported by the restatement, are absolutely evident from the complaint. The cases do say that the existence of a privilege is a matter of law. It is appropriate for the court's analysis at this stage.
However, again, we're at the pleading stage, and even if that were true, the conditional privilege can be abused if the publication, if the defendant in this case knows or it's false or has reckless disregard for the truth, correct?
That would help the appellant establish an abusive privilege, yes.
And that is alleged in paragraph 32, that the statements were published with knowledge of their falsity or in reckless disregard for the truth or falsity. So having alleged that, how can that be dismissed under 12b-6?
The court below found, and it'll be no surprise to Your Honor that we agree, that the fact that the statements did not contain any provably false factual statements about.
Well, now you're going back to whether it's defamatory in the first instance.
Well, this was the basis upon which the Justice Archer found that there was no abuse of privilege here. There can't be actual malice or reckless disregard as to falsity. She specifically wrote that it didn't contain any provably false factual statements, didn't identify her by name.
But the point is, you're implying that there are facts that are false. And if your opinion is implying, when you say we need to protect the community in conjunction with a criminal trespass notice, can't we leave it to the jury to decide whether that's, whether you're saying, we know this person's dangerous, so that's why we're taking the actions we are?
Well, again, obviously, there's multiple interpretations here. We don't believe that it does say that or necessarily says that, but the court's analysis was to hinge this malice issue, this abusive privilege issue, on the fact that there were not specific statements or provably false statements about plaintiff. The cases do draw a distinction between an analysis of the malice issue as opposed to other elements of defamation, and that's clearly what the court did here. In the context of analyzing the malice issue, these statements weren't specific or good enough, and we agree that that's a correct statement of the law. However, I will also say, before we even get to the privilege issue, there's a whole bunch of fatal defects here on the defamation claim, even before deciding the privilege
Well, you
issue.
say that it's like Bacall, but in that case, we have to look at it in context. The threat there was the threat of more litigation, because that's all that had happened in the past, was everybody suing each other. Well, here, the context is, according to the allegations in the complaint, there's a criminal trespass notice, and then there's a statement that says we had to do it, had no choice, because we had to protect the community. You don't think a jury could find that is implying some facts that they allege aren't true?
A few things there. The notion that a statement of, well, first of all, we believe it's a statement of opinion, not we had to, we felt that we had to.
Because had to.
It says had to.
Okay. Well, we believe that the effect of the statement, as should be concluded by the court, is a statement of opinion. But I understand that the appellant is arguing that a statement of opinion can essentially be undercut if there are undisclosed facts that create a defamatory
Well, that's the
situation.
law, isn't it?
It is the law, but the key word is defamatory. They have to be defamatory, undisclosed facts. Every statement of opinion could be said to have some sort of facts underlying it. You can't say something without it having to do with some substance in the world. There has to be a line here somewhere.
Isn't the point of this statement, although that's true, I mean, let me just put it this way. I read that and I went, wow, I wonder what she did. I mean, that was my reaction. And it sounds like the Stanford management, she must have done something really bad, whether it was to get terminated or something after the termination or something. I mean, doesn't that exactly fit into the idea that there's some facts that Stanford management must know?
I think it stands for first of all, it's a broad statement. It applies, recognizing that it does encompass Ms. Garey. It also encompasses all other former employees, whether.
But it was done in conjunction with the criminal trespass notice that was posted that was only for her.
Of conduct that this could be seeking to to
Could be. But
prevent.
isn't that,
It's that this is subject to multiple possible interpretations. The appellant is focusing only on the most negative possible.
Why was there any need to refer to the behavior of former employees?
So here
I
we
mean,
have.
clearly, Stanford had the right to issue a criminal trespass. There's no in question. Necessary to say the employees, we need to protect the lives under.
Your Honor, manager, 80 unit, the fact of a trespass denied, and they did itemize Ms. Dunham for professional reasons. Ms. Dunham completely said was,
Couldn't the letter have simply stopped at the fact that there was trespass?
I think
That happened, that required protection.
I feel that going further, I think the management company, as found by the.
I think putting up notice.
I don't think both the letter and both go into being this behind the appellant. For instance, but appendix page very serious.
thank you, Mr. Russell.
Thank you.
And reserve.
I would lose, but I also think that means that they were but beyond your dispute between a couple of landowners, to enforcement here that, and my friend, I think of them.
Conditional privilege to make statements.
One employer to a future prospective employee.
The employer can make statements. It's privileged in this. How could they can state?
So, say a fellow tenant. All we need is this letter was.
The employer doesn't necessarily, even under the, to send a notice to all of its customers, the employee.
Exact clients are important.
Controlation claim.
Your Honor, we are
An employer would be entitled
have the right to make